We're live.
Good evening, everyone, and welcome to the special City Council meeting for March 3rd. I will now call the meeting to order. Clerk, has the roll been taken?
Through the chair, roll call's been taken.
Members, are there any pecuniary interests for any items on the agenda today? All right, seeing none, there is one presentation on the agenda this evening. Item 3.1, John Muscarin, lawyer, certified specialist, municipal law, local government and land use planning and development, AIDS and Bearless LLP. And the topic will be closed meeting training for members of council. If there are no objections from council, Mr. Muscarin has requested 1 hour and a half for his presentation tonight. All right, seeing no objections, I would ask John Muscarin to come forward and begin his presentation. Thank you.
Good afternoon, Madam Chair and members of council. Thank you very much for having me this afternoon. Are you okay? Can you see me now?
Yep, we can see you well, thanks.
Terrific. I will attempt to keep myself to the hour and a half. I do have a lot of information on the slide deck, and let me tell you right off, I probably will not be able to get through each and every slide, but I had spoken to your clerk before and said that I will leave them with you for your future reference if you should ever like them. But I won't be able to go through each and every slide, but I think it might be helpful for you to use the slide deck as a resource. And I'll explain that as I'm going through. So, Madam Chair, if it's okay with you, I'm going to share my screen now, and I will put up my slide deck.
Please do.
All right, it looks like it's up now. So my topic today, Council, is open and closed meetings. And as a brief introduction, here it is. This is the open meeting rule in Ontario. It's as simple as this. It's in section 239 sub 1 of the Municipal Act. And it says, except as provided in this section, all meetings shall be open to the public. So what you see right away is there's a couple of things. One is the imperative mandatory shall. All meetings shall be open to the public, except as provided in this section. So there's an inherent exception that's built in right into the first opening section. The City of Brantford, wow, I even pulled a case from your jurisdiction. It sets out that the open meeting requirement has two basic rationales. One is to increase public confidence in local government, and two, to prevent secrecy in municipal decision making. And that was from a case from about 13 years ago that it went all the way to the Ontario Court of Appeal. So here is a brief outline of where I'm going to take you this afternoon, members of council. I'll talk a little bit about the open meeting rule. What actually constitutes a meeting? What is the new definition of meeting in the Municipal Act? A little bit about electronic meetings and things like electronic transmissions that could become potentially illegal closed meetings. And then we'll get to the real meat of the topic this afternoon, the closed meeting exceptions in section 239 sub 2, 239 sub 3, and 239 sub 3.1. There are 14 specific exceptions that are set out, and I'll run through most of them, and some of them in a couple of them in a little bit more detail. Then we'll talk about some other things like what are the procedures to go in camera? Are they mandatory? Do you have to do them? Can you vote when you're in a closed session? Who's allowed to attend a closed session? What about the record keeping? A little bit about closed meeting investigations. What are the requirements? Are there any for reporting out? What about confidential information at closed meetings? And then I will wrap it up to talk about some common problems, and then I'll finish off with some best practices. And hopefully, if I've kept to my timelines, perhaps there might be a little bit of time if any of you would like to ask me any questions. So going back, the open meeting rule, the rule is all meetings of councils, local boards and committees of either of them, and the committees is a specifically defined term in section 238, must hold their meetings in an open public forum. And there's the open meeting rule again. Requirement for all meetings of council, local boards, and committees of them. Committees, by the way, only committees that comprise of at least 50% of the membership is of members of council. Okay, so that's the requirement there. Anything that has less than 50% of members of council or members of local boards is not a meeting that, or is not a committee that then is subject to the open meeting rule. So your municipality must have some committees that aren't comprised of members of council or less than 50% of members of council, laypersons. Those are not subject to the open meeting rule. They can be if you'd like them to be, but they're not required to be. There's an historical context to this. The open meeting rule is a statutory rule, and that was made absolutely clear because in the 1910s, there were two court decisions. The media, the newspapers, the media at the time, argued that councils were going in camera all the time to make decisions, and they should be done in an open and transparent manner. And the court said, no, that is a statutory requirement, and there isn't one in Ontario. Well, almost 100 years, over 100 years ago, the open meeting rule was put in place for the first time in the Consolidated Municipal Act of 1922. And that stayed in place for a good number of years, 72 years to be precise. That same rule stayed in place. And then in 1994, things changed. The modern version of the rule was introduced through an amendment into Section 55 of the old Municipal Act. And that changed the rules. Before 1994, what was a meeting and what was allowed to be closed was generally based on the type of meeting rather than the subject matter. And what the courts and what the provincial legislature found was that municipalities were often circumventing the open meeting rule by just having the main business of their meetings conducted at committees and not at council. So many councils decided to get around the open meeting rule by saying, okay, we won't hold a council meeting. We'll get together as committee of the whole, and we're going to do our business, all of our deliberations, enclosed. And there was nothing to preclude that because the rule before 1994 said you could go in camera only if you, the open meeting rule only applied to council meetings. So you could go in camera for any other things if it wasn't a council meeting. So this changed when the subject matter exceptions were put in 1994. And now there was a further amendment, a significant amendment back in Bill 68 a few years ago. And I'm going to talk about that in just a moment. That made some significant changes to the open meeting rule for the first time in about 25 years. Okay, the current version is now put in place in what is now Section 239 of the Municipal Act. So the City of London and RSJ Holdings case is the most famous case dealing with meetings, went all the way to the Supreme Court of Canada. And the court said this: the open meeting rule reflects a clear legislative choice for increased transparency and accountability in local government decision making. And what the court went on to say is accountability is not only held every 4 years at the ballot box, it's held more frequently. And so there has to be transparency, accountability, openness. And so therefore the open meeting rule seeks to enshrine that principle here in Ontario. And by the way, it's the general rule with some variations throughout all of Canada. Brissenden Hill is a really fascinating case from the Divisional Court. I like it, and I always mention it right up front, that there is no absolute requirement for any person to be able to say, I have a right to appear before a municipal council simply by making a demand. Council can control its own processes by allowing or not allowing persons to come before council to participate. Now, one of the most fascinating decisions that I've seen in the last number of years was Mann versus Saugeen Shores in 2023. Mr. Mann was a lawyer. Is a lawyer, and he doesn't like what's happening in Saugeen Shores, and he decided he was going to use the delegation authority under the procedural bylaw of the municipality to attend, and to attend frequently and often in front of council to express his views. And he argued that he had a right to absolutely do so. And the court case, in fact, said the opposite, that there is no absolute and unfeathered right to any person to attend before council to talk about whatever they want, even though sometimes council allows open mics, delegations, open forums, whatever you would like to call them. There still could be rules. Mr. Mann argued, and he brought forward a constitutional challenge to a number of provisions in the procedure bylaw in Saugeen Shores, arguing that they were unconstitutional and infringed his right to freedom of expression. The court came back very strongly and said, you know what? You're right. There is a restriction on your right to freedom of expression because you can't say anything you want at a council meeting because there are rules. They said those rules, though, are primarily saved by Section 1 of the Charter, reasonable limits in a free and democratic society. And in this case, the court came back and said to Mr. Mann, who said, I'm entitled to go in front of council and say anything that I want, anytime that I want to. The court said, no, there are reasonable limitations that are permitted in procedure bylaws. Remember, the basic rule is that council meetings must run effectively and efficiently. In fact, that's one of the requirements of your head of council that is set out right in Section 225 of the Municipal Act. The head of council presides over council meetings unless the head of council is not present, right? And any chair has that responsibility. And the court also pointed out that all levels of government have some form of procedural rules or processes to govern the conduct of their assemblies. So even though Mr. Mann had argued that he was disentitled 11 separate times to appear before council, and that was a breach of his right to freedom of expression, the court said it may restrict your freedom of expression, but it is a right that the municipality has to curtail it. It's a reasonable limit. And what were the reasonable limits? The court looked at it and said, these are typical limits that you see in other procedural bylaws. Things like you cannot continue to bring forward items that you've already talked about. If you've talked about it before, you're not allowed to talk about it again within a certain period of time. You may not be able to address things like matters that are before litigation or criticize staff. You aren't able to come in front of council and give profanity-laced diatribes. That's prohibited. And you can't talk about union negotiations or contract negotiations or matters that are under litigation. All reasonable limits, the court decided. So put them all in place. But here's the main takeaway, and I love the case for this. Mr. Mann also argued that the right to a person's freedom of expression under Section 2B of the Charter also included the right to meaningful communication with one's elected representatives. And the court said, Mr. Mann, you're absolutely right. However, it doesn't mean what you say it means. And what Mr. Mann thought it meant, and what he argued before the court, was that he was entitled to go in front of council, and in having meaningful communication with the members of council, he was allowed to ask any questions that he wanted. And here's the kicker, and Council had to respond to him, and the court said unequivocally, no, that is not the case. The right to meaningful communication with your elected representatives does not extend to imposing an obligation upon members of council to respond to questions or demands from residents or other persons at meetings. That's a really fascinating case, and I really thank Mr. Mann for bringing it forward. He didn't get at all what he wanted, but what he got, I think, is some really good decision-making from the court for municipalities. So please bear that in mind. Just because your residents come before you and they may make demands that you answer, you don't have to do so. I love to extrapolate this case in just general terms. Do you have a right or an obligation, a duty, a responsibility to respond to each and every question that's put to you because you're an elected representative? Or does your staff have that responsibility? Do they? The answer is no, in general. Now, this case was in, of course, a meeting case. That's what it dealt with, a procedure bylaw, procedures at council. But I think the case can be extrapolated, and you don't have to answer each and every question that residents put to you. And I think this is something that municipalities struggle with all the time, because why? You're in the service business, right? You're responsible and beholden to the public, but that doesn't include answering every single question that's put to you, especially when the questions are put to you not to get answers, but to get a response to ask more questions. And the courts have stated that in a number of instances. So the City of London case also goes back and says, and I think this is important for council to understand, it relates to a resident, a taxpayer, a citizen's right to observe local government in action. It is distinct and separate from a citizen's right to participate in the meeting. So again, remember that when you have people coming before you and arguing that you have to listen to them. You do not. You can put reasonable limits in your procedure bylaw. You can instill reasonable limits at a council meeting to control the process of the council meeting to run it effectively and efficiently. Best practices, the open meetings guide that the Ontario Ombudsman puts out says this as well. There's no automatic right of anybody to participate or speak at a meeting, meaning someone who is not, of course, council, the assembly, that the meeting is there for them to conduct business. So moving on to meetings, here is what the definition of meeting used to say prior to, I believe it was January 1st, 2018, when Bill 68 amendments came in. It used to say a meeting means a meeting. That's essentially what it said. Kind of a circular definition. And by the way, terrible legislative drafting. I think you're taught, legislative drafting 101. You don't use the word that you're defining to actually define the meaning of the word, right? So that's what it used to say. Then this was taken by the former Ontario Ombudsman. And by the way, I am showing you the cover page to a closed meeting investigation report. This is not an AI generated joke. This is an actual cover of the Ombudsman's report on a closed meeting investigation in London that the Ombudsman said at the time it is the most complex, time-consuming, expensive, thorough, and complex investigation that this office has ever done. And let me tell you that they got it wrong. And if you'd like to see how they got it wrong, my partner and I represented the mayor and 6 members of the City of London in the case, and we explained to the Ombudsman how he totally got it wrong in the decision, in the report, because he appends our opinion or our submissions to him as Appendix A. So if you'd ever like to have a look, it's easy to find out. We argued that he made an absolutely incorrect decision, and he did so because he misinterpreted the word meeting, and he read it incredibly wrongly relied on some US case law that didn't apply in Canada. And the definition of meeting was quite clear, and the courts had said so in a couple of cases dealing with the media, arguing about closed meetings. And the ombudsman just got it wrong. Well, the province saw fit to go back and actually correct it by making a statutory amendment. The Bill 68 amendment reads, now you'll see in underlined text, is the old definition of meeting. But now there's two criterion put there. A meeting means a meeting where a quorum of members is present and where the members discuss or otherwise deal with a matter in any way that materially advances the business or the decision-making of the council, the local board, or the committee. That's the new definition. A vast improvement over what was there before. Quorum, the general rule from section 237, a majority of the members of a municipal council is necessary to form quorum. As you may know, there is a recalculation or recalibration of quorum that is permitted under Section 7 of the Municipal Conflict of Interest Act in recognition that at certain points, there could be a sufficient number of members of council who declare pecuniary interest and want to abide by their statutory requirements. But then it may cause a municipality to lose quorum as defined under Section 237. And it actually allows quorum to go down to 2 members. So your council can go down to 2 members. It could, if those other members declare pecuniary interest. If you have less than 2, you only have 1 member standing, or everybody declares a pecuniary interest, well, there's a mechanism in the Act, and you can, as a council, make a decision to go to court to get special authority for court to allow you to still continue to make the decisions, even though you may have a pecuniary interest. So just going back, the first requirement is you have to have a quorum of members present. Quorum of members doesn't mean just physical presence. It means presence. That could be virtual presence, and there's a recent case on just that point. And by the way, it means all of council. So it has to be quorum of all of council, not just members who are present at the meeting. You have to have a quorum based on the members of council, okay, the total members of council. The second one is a material advancement. Material, in my view, reading some of the reports, means significant. Business or decision-making, my view, is something that forms a normal matter, normal issue, typical question, or the standard types of concerns that are normally considered by the council. It must be something more than what the Ontario Ombudsman said in this report, because what he said is, all you have to do is lay the groundwork, do the groundwork to exercise power and authority. And quite honestly, that's contrary to what the courts had said. The courts had said what you need is a quorum of members present, and somehow you need to be advancing the business or the decision-making. So business and decision-making, 2 different terms. They don't mean the same thing. They could be quite different. So you need those 2 criterion to be fulfilled in order to have a meeting, okay? I want to just briefly mention electronic meetings. As you probably know, once upon a time, all council meetings had to be in an open public forum. There was a limited permission put in place for electronic participation. That wasn't really electronic meetings. It would just allow a member of council to participate in a council, provided that a quorum of members was physically present at the location, and it would allow another member to come in, whether by virtual means or telephone, or I guess some other type of means. Okay, that was all changed when COVID happened, right? All of a sudden, You had restrictions on contacts with other persons, gatherings. You can only have so many people at a gathering. So all of a sudden, how could the business of council continue? An amendment was made. The Municipal Emergency Act came in, amended Section 238, and said council can meet virtually. And if they meet virtually, they can meet to change the procedure bylaw to allow their meetings to be held in a virtual format. And it was good. That's what was determined. Actually, instead of stymieing a democracy, I think it was seen as advancing democracy, would allow many people to attend council meetings. Because what's the purpose of attending an open meeting of council? It's not necessarily to participate, even though there may be some participatory aspect to the meeting. It's really there to allow the observance of it. And so virtual meetings completely fulfill that one requirement. So this was looked at as a very good thing. And so the COVID Economic Recovery Act said a municipality can make its own decision and it could provide amendments beyond council or sorry, a declaration of emergency at the local level or a declaration by the premier at the provincial level. You can have virtual meetings at other times, including hybrid meetings. The difficulty, and this is where you have to be very careful, is members are not entitled to meet by any electronic, digital, or virtual means unless you actually are authorized by your procedure bylaw to do so. So please, please, please be very careful. If you're getting more than a quorum, or at least the quorum of members are present in a virtual setting by Zoom, Teams, Facebook, Skype, a teleconference call, you're in a chat room, you're sending emails to all members or a majority of the members, you're leaving serial phone calls and messages. All of those things can create an illegal closed meeting if you have quorum of members present and you are advancing the business or decision making of the municipality. I mentioned two recent cases. For the first one, the McKellar case from 2023, for the purposes of an electronic meeting, the meeting place is the electronic setting. So you don't need physical presence. This is a bit of an about face by the Ontario Ombudsman, who had originally taken the position that no physical presence is required. I did never believe that, because if the statute wanted to say physical presence is a requirement for quorum, it would have used the words physical presence. And it has in other statutes, but not in the Municipal Act. So you could always possibly meet virtually. And then the Township of Frontenac goes to the exchange of emails. And this case said when members of council exchange emails, they are present in an electronic place. So be very, very, very careful that if you, as members of council, write to all other members of council and it's something to do with the business or decision making of the council, then you may be perpetuating an illegal, improper closed meeting by having it outside of an open public meeting forum in accordance with the procedure bylaw. I just wrote a report on this, castigating a municipality for having done this, having exchanged a number of emails about the funds in a reserve fund and what they were to be used for. And there was a series of discussions through emails that were sometimes copied to all members of council, sometimes not. And then again, other people chiming in, and it clearly constituted an illegal public meeting, an illegal closed meeting. So please, please be careful. There's nothing wrong, I'll say it, nothing wrong with someone sending out an information only email to all members of council. But what it should do is it shouldn't advocate a certain position, it shouldn't state opinions, and it shouldn't certainly be responded to by other members, because once someone else responds, even if someone says this is for information only, but someone comes back and starts responding and copies everybody, you could have an illegal meeting there. So please be careful of that. I'll leave you with that. Closed meetings. So this is where I'll probably spend the bulk of my time today to talk to you about the 14 separate closed meeting subject matter exceptions under the Act. Going back again, in general, all meetings have to be open to the public. However, it is an entitlement of council or a local board or a committee to be able to go in camera, closed session, to consider certain subject matters. First of all, the exception must be found within Section 239. I have a bit of a refinement on that, and I'll talk about it in just a moment. But in general, the exception must be somehow found in Section 239 and not elsewhere. There are limited exceptions to the open meeting rule in 3 subsections. I named them right at the beginning of the session. And the exceptions are based on a subject matter, not on the type of meeting, but on the subject matter to be disclosed. There are 14 separate specific closed meeting exceptions. They're set out in 3 subsections. The first 11 and the very last one, so 12 in total, they are entirely discretionary. And I'll speak about that. Many people get confused. Many council members will say, oh, we're talking about the security of the property of the municipality. Oh, we're talking about labor relations. We must go in camera. That's not true. You don't have to go in camera. It's entirely discretionary for 12 of them. However, there may be very good reasons why you would proceed and convene in a closed session, and I'll speak to those. There are 2 limited exceptions that are mandatory, that you can only speak about those subject matters in a closed setting. I will speak to them, but I won't be long on them because they're not used all that frequently. In general, the interpretation is the exceptions have been interpreted and applied narrowly and restrictively by closed meeting investigators and by the Information and Privacy Commissioner of Ontario, as well as the courts. Now, the reason I say the Information and Privacy Commissioner is many of the exceptions that are in the open meeting rule are also exceptions that are in the Municipal Freedom of Information and Protection of Privacy Act, MFIPA, and I will highlight a number of them in just a moment, okay? What are not exceptions and what council is not entitled to go into closed session for is subject matters that are in and of itself controversial, sensitive, provocative, salacious, or contentious. By themselves, these things do not form the basis for a closed meeting. There may be a subject matter in one of those other 14 exceptions that is controversial, that are sensitive and provocative and so on. But on their own, just because something is very controversial in the municipality doesn't mean that you can talk about it in a closed session. So I'm going to highlight now, and I'll show you all of the first 11 exceptions, and I'll have some comments on the latter ones that were brought in place by Bill 68. So just let me run through them, and then I have a series of slides where I have detailed commentary, a cheat sheet, if you will, for each of the exceptions. Time will not permit me to go through each of them, but I hope to be able to at least go through a couple of them for you, okay? So here they are. Here's the exceptions. The first 3. Meeting or part of the meeting may be closed to the public if the subject matter is A, the security of the property of the municipality, B, personal matters about an identifiable individual, 3, a proposed or pending purchase or sale of land by the municipality, Okay, those have been in place since 1994. The next 4 have also been in place since Section 55 of the old Municipal Act. Labor relations or employee negotiations, litigation or potential litigation. Notice the trailing words, including matters before administrative tribunals, for instance, the ARB, the OLT, the Landlord Tenant Board, the ERT, the ETR, ERT, Environmental Review Tribunal. Advice that is subject to solicitor-client privilege, including communications, and a matter in respect of which a council, board, committee, or other body may hold a closed meeting under another act. Now, G is the one that I said there's a caveat to this. Remember I said earlier that in order to find a closed meeting exception, you have to fit it somehow within Section 239. Well, G says that you can go in camera in a closed setting to discuss something if there's another board, committee, or other body is entitled to have the matter considered in a closed session, and that body or that representative is before you. Let me give you one example. Police Service Board. You probably have somebody on your council who's a member, maybe more than one, who's a member of the Police Service Board. Under the new statute, and I always forget the name, the Community Safety and Policing Act, it has closed meeting provisions in that act for what used to be called police service boards. So if the Police Service Board meets and has a closed meeting, which they're allowed to do for different subjects under that statute, if the police chief or your council member who's a representative of that board comes to council and wants to disclose something that they're entitled to disclose to council, it can be done in a closed session because the other statute permits it. Public Libraries Act is the same way. There are a number of exceptions in the Public Libraries Act, and it allows a public library board to have closed meetings for certain things. And if they're held in closed meeting, then if that information is to be transferred to your municipality, then it can be done also in a closed meeting. Okay, but the exception legally is found in Clause G. Now, those are the 7 closed meeting exceptions that pre-existed the Bill 68 amendments. Bill 68 then added 4 new provisions, and I'm going to show them to you right now. The first one, information that's explicitly supplied in confidence by another level of government. This is when the province wants to do something for you, give you something, or talk to you about something. And it says, we have to meet in camera. They can ask for that. They have to ask for it expressly. And the council can meet in camera with the minister or with representatives from the provincial government, the federal government, or a crown agent in camera to discuss it. You can do that. Notice that after I put the actual word, the quotation there, I have a reference in bold. Section 9 of MFIPA. That is the same provision, or essentially the same provision, that's found in MFIPA, one of the exceptions to disclosure under Freedom of Information. Okay? In I, there is the third-party exception, third-party information exception that is found in Section 10 of MFIPA. And that relates to a third party coming to council and saying, look, I'm going to give you some information, and you're entitled to look at this, but please look at it in a closed setting because the information contains things like commercial, financial information that would be adverse to me if that information were to go out. I like this one because I typically do most of my work as a municipal lawyer, and sometimes I have to bid on work for a municipality through a public procurement process. And I completely understand that if I submit a proposal to a municipality, the municipality would like to know, what are my fees? What are my rates? Will I offer a discount? What will I do? How will I populate my staffing on files? I think that's all great information that you should have. What I don't want, if I give it to you, is for my competitors to have it. This provides that I can tell you implicitly or explicitly to please protect the information, and then you'd be allowed to go in camera to consider that. And that is to get away from the chilling effect it may have with third-party bidders for municipal work or services, where they would not provide the information to you if the council were to just have all of these meetings in an open session. There are two more. Two more. There are two more. J is the corollary to the third-party information. It's information that's trade secrets, scientific, technical, commercial, or financial information that belongs to the municipality, that may be monetized, and you wouldn't want that information necessarily to get out. I'll give you one example. The municipality says, we got the private sector doing this kind of work, but you know what? We could create a municipal service corporation and we could compete with the private sector and do a better job. Now, if you went out and disclosed all of that, you might be giving a leg up to those private sector business corporations. That is something that you can have, that you might be able to monetize and use that information, and it has value to you. You may not want your neighbors to know about it because you may want to be the municipality that does this and then potentially offers that service with the consent of other municipalities. So this is a reason why Jay would protect that information on behalf of you. So as I said, it's almost the counterpoint to the closed meeting exception for third-party information under I. And then the final one that relates to Section 11E of MFIPA is when the municipality is formulating something to be carried out or is carrying out negotiations with someone. So you have to get together to establish a position, plan, procedure, or instruction to be applied to negotiations, okay? All of these exceptions, including the 4 new ones, which all seem to relate back to align the closed meeting exceptions with some of the exceptions that are found from disclosure of FOI requests under MFIPA. All of these are discretionary. Council does not have to go in camera, but they may want to go in camera. So I'm going to go through just a couple of them. I think every closed meeting exception that I've just shown you, all 11 of them, I have at least one slide with detailed crib notes for you. I won't be able to get through all of them today. Okay, I'll just tell you that. I won't. I'm going to go through 2 of them. The first one, security of the property of the municipality. The term security, not defined, but in my view, reading the reports, it appears to relate to the protection of the property of the municipality. Property does not just mean real property, which is the position that the IPC originally took, even though it's really odd because that word property is used in the Municipal Act. And when it says real property, it means real property. When it says property, it means both corporeal and incorporeal property. So for instance, it could mean official marks, trademarks, copyright, could mean those things that aren't real property or personal property. Okay, so property writ large. The purpose of it is to allow the municipality to secure, to protect the information that might go out to the public. So for instance, I'll give you one example here. The municipality would like to purchase protection insurance for cybersecurity attacks, right? To protect municipality from cyber attacks. Do you necessarily want to have all of that discussion in an open public forum so anyone who might want to perpetuate a cyber attack would know exactly the limits of your coverage? Again, that would protect the property of the municipality by way of an insurance policy that you may purchase to protect you on cybersecurity matters. Okay. Personal matters about identifiable individuals. The purpose of this one is to protect individual privacy. Notice that it says personal matters, not personnel matters. This isn't something that has to do with HR. It's personal matters. Many people said to me, why doesn't it say personal privacy? That's the definition in MFIPA, personal privacy. There's a list of things, personal information that's protected. Personal matters, in my view, was intended to be broader than just personal information that's under MFIPA as defined there, okay? And there's some things that it doesn't apply to, okay? Oh, there, I go to MFIPA. Personal information defined very specifically. My view is it includes personal information, but personal matters is something a little broader, okay? Acquisition or disposition of land in Clause C. The purpose of this exception, as you'll see in a couple of other exceptions, is to protect the municipality's bargaining power. This is very important for when I talk to you about who's entitled to be in the meeting, okay? So just park that for a moment. The purpose is, again, to protect the municipality's bargaining position. The municipality must be the prospective buyer or seller of the land. The land applies to more than just the fee simple. It can include interest in land, like leases, easements, licenses, okay? Excuse me. The consideration must be proposed or pending. It can't be something that's just potential or speculative, right? Anything can be potentially, right? So you can't have a meeting going, let's talk about this because maybe 20 years out, we may need to have that park. It has to be something much more concrete. It's a determination that's on a case-by-case basis. You cannot have a bright line test to say that's exactly what it means by pending, that's exactly what it means by proposed. But it has to be something that's more than just potential or speculative or hypothetical, okay? So this is one of the exceptions that I often point to when someone says, oh, you should always discuss things in an open public forum. You should never go in camera to discuss things. Just think about how silly that is when you're considering purchasing lands from somebody. Let's say your municipality has done a study and it's found that the most important, most perfect piece of land to do something for the municipality is this specific parcel that you've identified. It's owned by a third party. If you were to have that discussion in an open public session, don't you think that the person who's listening all of a sudden says, wow, I've got the perfect piece of property. So quite honestly, I can hold the municipality to ransom for that property because I know it's the most perfect piece of property to do whatever they want. Put in a stormwater management pond, put the cultural or arts center right there. So your price goes up. So there is a real public interest sometimes to having these discussions in closed to protect the municipality and to protect the public interest. Labor relations or employee negotiations, again, why would you do this in closed? To protect the municipality's bargaining position. This is another one where you would have this, okay? So Let's go on. Litigation or potential litigation, right? If you're going to be sued and you know you're going to be sued, again, it has to be a reasonable prospect of litigation. That's what the RSJ versus London Holdings case said before it actually got to the Supreme Court of Canada. I was doing some training at orientation the last go around. I remember a council member went to me, "Oh, that's pooey. We can do almost anything under this because anytime the municipality does any act, sets out its minimum service standards for snow plowing in the winter, we could be sued." And I'm there, yeah, but you have to have a reasonable prospect of litigation. He didn't believe that until I showed him the actual quote from the case. So again, this has to be real. It has to be something that's real, that has a real basis, okay? Solicitor-client privilege, there's a three-part test to it. There has to be a communication between the client and their lawyer. It could entail just the seeking of legal advice or just the giving of legal advice. Many people get this confused. They think it has to have both parts. No, counsel is allowed to convene in closed session just to determine, do we need an opinion from a lawyer? Do we need representation? And what do we need it on? You're allowed to do that, and you're allowed to go into closed session to discuss solicitor-client privilege if all you're doing is seeking the advice. And the third part is it has to be considered to be confidential between the parties. The fact that a lawyer is at the meeting or not at the meeting is immaterial. In fact, one of our first closed meeting investigation reports pointed out that the city of Stratford was illegally in a closed meeting. They argued, well, we had our lawyer there. When we investigated, we found out the lawyer was not there to talk about item A on the closed meeting agenda. The lawyer was there because she was asked to talk about item B, and she had nothing to do with item A. And they weren't talking about getting advice from a lawyer. So the fact that a lawyer is there or not there is not present, is not sufficient. Closed meeting under another statute. I mentioned this before. I have the reference to the old Police Services Act. Of course, that's been now updated. The Emergency Management Civil Protection Act has provisions for closed meetings. So does the Public Libraries Act. Confidential information, it could be provided by the federal government, the provincial or any territorial government, or a crown agent of either of them, and the information must be expressly provided and supplied in confidence. Unlike the third-party information, where it can be only supplied in confidence implicitly. It doesn't have to be explicit. There are 6 categories where it may fit under, and the third party must make out that it would significantly prejudice their competitive position or significantly interfere with their contractual relations. Okay, there is a reasonable expectation of prejudice, and there's a case. There has to be a reasonable expectation of harm that is in place there. Now, for closed meeting exceptions on J, notice that I've crossed out one of them. There's only 5 categories here because, of course, one of them is already subsumed under Clause D, which is labor relations or employee negotiations, okay? Positions for negotiations, there is a 4-part test. I will leave you with this. This is a new exception, and again, it relates to Clause 11E of MFIPA, which is a similar exception for the non-disclosure of information under FOI under MFIPA. All right, so I'll leave you with those. Here are 2 other specific exceptions. These are the ones that are mandatory. They are little used, okay? The first one is if counsel is the head for decision-making under FOI. If you were to have the discussion by counsel in an open session, then you would be disclosing all kinds of problematic things. So if counsel is the decision maker for FOI, then you have to have it in a closed session. And B was added because of a case that came out, pirating our privacy, where a closed meeting investigator had provided a draft report to the council, and someone made a request for it, and the municipality disclosed it. Now, that closed meeting report from a closed meeting investigator or an ombudsman's report or some other investigator has to be dealt with in a closed session. So if council ever receives a draft of a report from a closed meeting investigator, you have to go in camera to consider it. And then finally, the last exception is for education or training purposes. And you have to pass a resolution, and both of these conditions have to be met. It can't materially advance the business or decision making of the municipality. The exception is a permissive, not a mandatory exception. You can have an open meeting to have training and education. The exception has been applied narrowly and very restrictively. Here is the ombudsman talking about this, arguing that you have to have a closed meeting if you're having a meeting for education and training, the only purposes of the meeting must be for education and training. And this is where councils sometimes run afoul. You have the educator there. The educator may be a planner, maybe an engineer, maybe a consultant, maybe a lawyer. And all of a sudden, you go from general training to a specific matter that might be coming before council to try to apply the education and training portion of it. And all of a sudden, you've run offside the closed meeting rules. So please just be aware of that. You can only have training and education strictly and exclusively only for education and training purposes. You cannot commingle it with any other exceptions. Here is one that I find comes in very handy. Sometimes you're in a closed meeting, and sometimes you're discussing something that's properly in the closed meeting, but then you're thinking about it, you're going, a lot of this discussion maybe should have been done in open session. So here is one case based on its specific factual circumstances where the court said, you know what, council, you're in closed session to do this. Maybe you should have come out of closed session, but then you would have had to go back into closed session, and then maybe you would have had to come back out. And it's stupid to actually parse out council meetings in that way. It's too difficult sometimes to toggle back and forth. So there is a judicial recognition in this St. Catharines case where the court determined that where some matters are inextricably connected, it's just too difficult for council to toggle back and forth. And so the courts, the judges, have determined that sometimes it's just permitted for you to remain in a closed setting, even though some of the conversation maybe properly should have been held in an open session. That's always a very mixed fact and law decision to make. It's very difficult on the spot. And I would say to you, listen to your qualified clerk on this. If he or your deputy clerk says you're going offside, council, this discussion maybe should be an open session, please be aware that you have to be careful. It's a specific determination that you have to make on a case-by-case basis, but you won't necessarily be held to be offside the open meeting rule if you have maybe a little bit of discussion that maybe should have been an open, but it's so connected to the closed session that the courts will overlook it. Okay. So that's the big part of the meeting because it dealt with all of the exceptions. I'm now going to turn to a number of rules. I will try to get through this quickly. I have the less slides left, and I'll try to cover this off in the next, say, 20, 25 minutes. Okay. You need an authorizing resolution to go into closed session. Absolutely. It's mandatory. Council has to state by resolution why you're going in closed. You have to state why you're doing that, generally by reference to the closed meeting exception. But look at this. You also have to state the general nature. So typically, the Ontario Ombudsman and other closed meeting investigators have typically taken the position that you can't just say we're going into closed to consider a personal matter about an identifiable individual. Yeah, typically have to say a little bit more than that. Now, this gets difficult. What if you wanted to say, going back to my example before where I said, hey, if you wanted to purchase lands, I had one clerk say to me, well, it's easy when you're talking about the pending acquisition or disposition of land because you just identify the property. And I said, maybe not, for the very reasons that I said. So that's really tricky. Again, I would say to you, please, please consult with your clerk on this and be guided by what your clerk, deputy clerk may instruct you on this. Okay. Sometimes it's very, very difficult to say very much, but the law typically is, well, it is in section 239(4) that you have to state why the meeting is being closed. And again, that's generally by reference to one of the exceptions, and then the general nature of the matter. Sometimes it's not so easy to do that. So here it is, the Farber case, which I will talk about again in just a moment. The resolution to go into close should provide a general description of the issue to be discussed in a way that maximizes the information available to the public while not undermining the very reason why you went into camera. Okay? And I put the very bottom note, a resolution that simply reiterates the wording of the applicable closed meeting exception likely will not suffice to satisfy this requirement for the authorizing resolution. There is limited voting, okay? Now, typically, you're not allowed to have a vote unless it's an open session. You are, in a couple of instances in the Act, to elect, I think, another chair or a deputy mayor or things like that. You are allowed to have secret ballots. But typically, you're not allowed to vote unless you fall within the exception. And there's two parts to it. There's two components. They're conjunctive. The first one is you're allowed to be in the meeting. So it's a valid closed meeting. The second one is the vote is for a procedural matter or for giving directions or instructions to agents, officers, employees, consultants of the municipality. Okay. Now, a number of closed meeting investigators have made the mistake, and a number of councils have made the mistake. We cannot make a substantive decision in camera. We can only make procedural decisions. And I say that's wrong. Where does it say that? I think the first words, the vote is for a procedural matter, often leads to an illogical conclusion that the vote is for a procedural matter only and you cannot make substantive decisions. That's how it's been interpreted by some really well-qualified closed meeting investigators. Just think about it. Just think about it for a moment. That is absolutely wrong. It doesn't mean that at all. Can you make a substantive decision in camera? Yes, you can. Just think about that. If you are speaking legal counsel, let's say I'm in camera with you. I've been representing your municipality on a litigation matter. And I've come to you and I've said, counsel, I need to talk to you about this. You have a $3 million lawsuit against you. And the plaintiff is making an offer of $10,000 and will walk away from it. And I'm talking to you. If you're going to give me instructions on that, aren't you making a substantive decision? You absolutely are. If you make a decision, John, we're instructing you, you can settle up to $10,000 and we'd like these conditions to be put in place. You're making a substantive decision there. And you're allowed to do so in a closed setting. It has to be couched as directions or instructions to certain persons. But please don't be misled that you cannot make a substantive decision. Now, what you couldn't do there is say, we're going to settle this for $10,000. It has to be couched in, as I said, instructions or directions. But you're probably saying to yourself, but this is wrong. We have to go out into open session and make that determination. I say you don't. If you look at Section 5.3 of the Municipal Act, Section 5.3 says the powers of a municipality have to be exercised by council by bylaw. It actually says shall. But then there's some trailer words there. It says, or as otherwise specifically authorized. This is otherwise specifically authorized. So you would actually be in compliance with Section 5.3 of the Municipal Act, and you don't have to go out and report that in an open session. Because if you were to report out that you're willing to accept that amount of money, just think about it, the price will probably go up, potentially. Okay, so you are allowed to make substantive decisions, but you have to be careful in how you make them. That's the best way I can say it. Attendance at closed meetings. Remember earlier I told you I was going to round back up to this? I get asked this all the time. Who can attend a closed meeting? Well, first of all, let me say the persons who are entitled to attend are all members of council, or members of a local board, or members of the committee, except any members who have declared a pecuniary interest, because Section 5(2) of the Municipal Conflict of Interest Act says those persons must leave the setting of a closed meeting, or other words, don't attend. Or they're somehow otherwise disabled at law. They have a closed mind, so they're biased, they're disqualified at law. They have perhaps a common law conflict of interest. They shouldn't be at the meeting because it could jeopardize the decision making. The clerk, or a person who's designated in writing by the clerk, potentially a deputy clerk as well, they're allowed to be at the meeting, have to be at the meeting, because someone has to keep a record of the meeting. So those are the people that have to be at the meeting, or that might be removed from the meeting. Who else is entitled to be there? Well, it's up to council. Council can have any other staff, consultants, agents, or persons at the meeting at council's discretion. However, that discretion is limited to the very purpose of the closed meeting exception. Remember, I said before that certain closed meeting exceptions are there to protect the bargaining position of the municipality, i.e., Clause C for potential pending purchases or dispositions of land. D for labor relations and other negotiations. K for negotiations and establishing a position or plan. Those are there to protect the bargaining position of the municipality. So if you were to have the vendor or the purchaser or the CUPE representative or the person that you're negotiating something with at the meeting, and you're actually talking about the things that you're going to be negotiating, you've lost the closed meeting exception, because that's not to protect the bargaining. It's not for the purpose of protecting the bargaining position of the municipality. So could you potentially have the vendor of property that the municipality is thinking of acquiring at a closed meeting? You could. They could come in, they could make their pitch, they could disclose that information that they wouldn't want to be released. But before the municipality starts considering the matter, right, and starts potentially negotiating, if that person leaves, you've got an okay meeting. If that person stays and you're talking about, oh, we'll pay you this much, or what are the conditions, and we'll give you a VTB mortgage, then you run offside and they're not allowed to be at the meeting, and you've got an illegally constituted closed meeting. Okay. Record keeping, I'll be very brief. Without note or comment, you need someone there. It's typically the clerk, the recording secretary, the deputy clerk. Sometimes you may not want the clerk or the deputy clerk to be at the meeting. Why? Because you might be discussing very sensitive matters, potentially about people who are their superiors or other people. You could always deputize someone else to be a deputy clerk for just that meeting, or the clerk typically can assign their responsibilities in writing to any person, provided that it's not a member of council, the local board, or the committee member who the meeting is for. Okay. Now, great question. Should you audio or video record your closed session? My view has always been that if you're having a discussion in closed session, it's for the purposes of having a full and frank and open discussion, pardon the pun, in closed session. So would recording it somehow take away from it? Would it derogate from that? I think it probably would. And this is a policy decision that all councils can make. Would it help if you were to have a closed meeting investigation and you had a video recording of the meeting? Unequivocally, yes. But if that's what you're worried about, I think then you've got your ideals misplaced there. It's not really for the purposes of keeping a record in case there's a closed meeting investigation. The purpose of the closed meeting is to protect the bargaining position of the municipality, allow certain things for the public interest to be kept in camera, and to have a full and frank discussion with members of council. The contents of a closed meeting record, the Ontario Ombudsman in their guide has set out a really nice short form, and I made it, I think, a little bit shorter than it is there. These are all things that your clerk must keep in mind in order to keep a record. Please let anyone know who's being deputized or coming in to keep a record and be the clerk for a meeting that you have to have at least these things, okay? Closed meeting investigations, I'll be brief. As of January the 1st, 2008, in the Bill 130 amendments, any person, not just a taxpayer, not just a resident, any person may make a request to the municipality, the local board, that an investigation be conducted for an express purpose to determine whether a meeting or part of the meeting contravened or complied with Section 239 of the Municipal Act. So did it comply with the open meeting rule? Or whether it complied with a procedure bylaw of the municipality. Many persons who file closed meeting investigation requests don't seem to understand that it's a very narrow request and jurisdiction that the CMI has. The investigator can only look at it to say, was the meeting properly convened? Did it follow proper procedures? Did it have a resolution to go in camera? Did they go in camera for a proper purpose? Was it identified? Did they stick to that? Those are the things that a closed meeting investigator will look at. Things that a closed meeting investigator will not look at is, did council make the right decision in camera? We get that all the time. And that's not something that closed meeting investigators look at. Who is the closed meeting investigator? Well, you can appoint someone. I believe the city of Brantford has. You can appoint a closed meeting investigator. If you don't, the default closed meeting investigator is the Ontario Ombudsman. Okay. The steps to the closed meeting investigation are here. The request is filed by a requester or a complainant. That person's identity remains anonymous. Okay. Typically, the CMI will do an intake analysis. We'll look at it. We'll determine, does this actually fall within my jurisdiction or does it fall outside? If it didn't come to the clerk, then the municipality is notified of the request. The closed meeting investigator will then do the field research that's required. We'll gather the information, review the record, look at the procedure bylaw, look at the agenda, things like that, interview witnesses, can issue a summons. Then there's a determination and findings of the matter, typically the drafting of a report. That draft report should be shared with the clerk, and the clerk can share it with the council, who has to consider it in a closed session. Advice may come back. Comments, corrections, requests for modifications can come back to the closed meeting investigator, who will then look at it and provide a final report to council. If there is a contravention found, then council is required under 239.212, a new section that was put in place by Bill 68. Council must pass a resolution as to how it intends to address the report, because sometimes a closed meeting investigation will set out that there's been a breach and then have recommendations. For instance, council needs training. Council needs to do this. Council has to have a protocol for how it conducts closed meetings, and so on. Council has to pass a resolution. And the reason that was put in there, many councils were receiving closed meeting investigation reports that were finding contraventions, were recommending things, and council would say, thank you, next. And they would move on without taking any stand to address the report. And of course, the report must be made public. As I said before, the consideration of the draft report must be in closed session. Report must be public, and there it is. Requirement to pass the resolution regarding the report. Okay. Reporting out from closed session. A question that I've been getting more and more frequently. There is no statutory, there is no regulatory, nor is there any legislative requirement for a council to report out what it's done in closed session. The practices vary from municipality to municipality. And I will tell you right now, like a lot of what I've told you today, there is no bright line test. There is nothing that says you have to do this, and this is what you have to do. Reporting out from closed session should, in my view, and I'll show you in just a moment, the view of the Ontario Ombudsman, should report out as much as can be safely reported out, while yet possibly protecting matters that are in the public interest and that need to remain in closed session. But there is no absolute requirement that council reports out. Where we do find breaches is typically where a procedure bylaw sets out something that says council must report out and must do so in a certain way. There's nothing in the statute, there's nothing in the regulation. However, we have found things in procedure bylaws where municipalities have decided to put in requirements. But otherwise, please be aware, there is no requirement to report out. And just because your municipality may have reported out in a certain way or not reported out in a certain way for years, and it's become almost an historical practice or custom, it doesn't mean that it's appropriate in any particular instance. Now, I will grant you, if it's not specified anywhere and that's become your custom or your convention, you may be at least partially entitled to rely upon that. Finally, confidential information. Closed meeting information equals confidential information. I looked at your council code of conduct, and it defines confidential information specifically to include information that was discussed during an in-camera meeting of council or of a local board, or that was information provided to the member for a meeting. So just because you may have received the lawyer's opinion ahead of the closed meeting, it is still confidential information from a closed meeting. And what does your code of conduct say? Members will refrain from disclosing or distributing confidential information, whether it was received at an in-camera meetings or otherwise. You cannot disclose that information. Now, it's been said that in-camera meeting information, closed meeting confidential information, it is a cardinal rule that it's not to be disclosed. It is not to be disclosed by an individual member of council. This is very, very important. There's a number of reports that speak to this. And most importantly, there is a case called Follis versus Aurelia, where Councillor Follis took it upon himself to disclose closed meeting information because he said it was important and he had to get a lawyer to look at it. And the court said that closed meeting information belongs to the municipality. It does not belong to any individual member of council. And there's been a number of reports from closed meeting investigations and from Integrity Commission investigations that say it doesn't matter if you think it was important for your group, your ward, your district. It's important for the municipality as a whole, and council has made the decision that it goes in camera. That information belongs to the municipality, and only council or a court can decide to release that information. It's not at the discretion of any individual member of council. Please, please, please remember this. I get this all the time. Council members reach out to me. They go, John, this is really problematic for the people of my district. They need to know. The rest of the council is railroading me. No one wants this, whatever, whether it's a homeless shelter, some sort of clinic, some other use that might be seen as possibly being a nuisance. No one else wants it in their wards. So I need to tell my members what's happening, my constituents what's happening. The first thing I say to the council members, look at the code. It says very clearly, it's closed meeting, confidential information. You cannot share it. Belongs to council. And by the way, when you become a council member, while you may be elected by ward, as in your municipality, you don't just represent the people of that ward. You represent every constituent in the municipality. Remember, there's a broader public interest that applies. So confidential information, the cardinal rule, belongs to the municipality. Council can decide what to release, when to release it. It is not up to a council member to do so. I've now come to the end. I'm just going to round up. I think I have a few more minutes. I'm going to close off, and then if there's any time left, and I'm in your hands, Madam Chair, I'm happy to take any questions. So, common problems. There is no closed meeting exception that's applicable. Remember I said just because it's controversial, contentious, salacious, sensitive, not a reason to go in camera. Okay, that's a problem. You choose the wrong subject matter to go into closed session, okay? You say you're going in to discuss this, but you're actually discussing that. There's a misalignment, that's a problem. You fail to comply with the procedural requirements. You don't pass a proper resolution that identifies the closed meeting exception and the general nature of the matter, okay? You have improper voting at the closed session. You have votes that are substantive decisions that aren't giving direction to someone. That's wrong. You're making decisions that aren't somehow falling within the scope of 239(6)(b) of the Act that are either for procedural matters or for giving instructions or direction. You have improper, insufficient record keeping. This happens a lot with clerks that are inexperienced. I don't think you have that problem with your municipality. There is a failure to report out in open session. Again, the general rule is you should report out for purposes of openness, accountability, and transparency as much as you can. However, because there's no legislative base for it, unless it's in your procedure bylaw, then there is no legal requirement. The best you might find in that particular case is a closed meeting investigator will look at it and would say, best practice would probably be for you to report out and to report out in this way, but there is no contravention of the open meeting. And then finally, the one that often rears its ugly head is you go in camera to do education and training, but then you deviate. You take a different road and start talking about substantive matters that significantly advance the business or decision making of the municipality. Remember, you can deviate a little bit if the matter is inextricably connected, and you can discuss some open matters in closed session, but be very, very careful about trying to rely on that judge-made rule too much. So best practices, briefly, try to provide notice of upcoming closed sessions if possible. Now, I appreciate the rule that says you have to have a resolution doesn't say you have to give advance notice of it. In fact, you may get something the day of the meeting. Something may come into your clerk, and your clerk says, council needs to see this. There is a meeting this evening, and I'm going to let the chair know about this. And potentially, this has to be a closed meeting matter that has to be discussed. So you wouldn't know beforehand. But if you can give notice to the public, it's a best practice. Pass a clear resolution indicating the purpose of the closed meeting. Select the correct closed meeting exceptions. There may be more than one. I find that when you have like 5 of them, it might be looking like a shotgun approach. Like, we're not sure which one applies. We're going to try them all. That doesn't look so great for a closed meeting investigator when they're reviewing that. At the meeting, please stay on topic during the discussion. Don't deviate in the debate to go to talk to other matters. You're talking about a litigation matter, possible settlement or possible resolution, or possibly commencing a lawsuit, right? Don't start talking about other matters. You're there to talk about that specific matters. Adhere to the closed meeting voting restrictions and limitations. I think I've talked about those enough. This is for the clerk or the recording secretary. Please keep an accurate record of the closed meeting. Remember, has to be kept without note or comment, but record all resolutions. Try to record the direction that's given, because people will have different recollections about what was said. Closed meeting minutes have to be approved. They can be approved in camera, because sometimes you can't have the discussion unless you're in closed, and you're allowed to go in closed for the same purpose in order to approve the closed meeting minutes. Try to report out as much as possible if you can. Remember, the rule is report as much as you can for the purposes of accountability and transparency, but don't give away the very basis for why you were in camera. And finally, and this applies not only to members of council, but members of staff, I'm sure your fiduciary obligations for senior members, your employment contracts, your appointments, the status of your office, perhaps your own code of conduct for staff says never, ever disclose closed meeting information unless you're authorized to do so. For instance, the treasurer gets instructions to do something. The treasurer may need to disclose to certain limited people, it's implicit, certain things about what was enclosed in order to carry out the direction or instructions of council. But otherwise, do not disclose anything from a closed meeting. That is one of the worst things that can happen. It could lead to all sorts of liability for the municipality. So, Madam Chair, members of council, I've come to the end of my presentation proper. I think I'm just about at time, but I don't have anything to do, and I'm pleased to take any questions, but I appreciate you've been very patient and you haven't been asking any questions throughout. So I will stop and take a breath, and I'd be happy to take any questions.
Yeah, that's perfect. We're actually going to take some questions, and I have Councillor Carpenter first, please.
Thank you. A question that I have for you. So you're in camera because you're looking at purchasing property, and that's proper reason to be in camera. It's all done properly. After you've made the decision the property's long been purchased, when can that information about that be released, or when should it be released to the public about what you bought, what you paid for it?
Yes. Thank you very much, through you, Madam Chair, to Councillor Carpenter. It can be released when council authorizes its release. Not before that. And I know this is a matter of some contention because some council members might say, but we've made the decision, we've carried this out, the public needs to know. But again, it's not up to them to release it, not up to staff. Council has to make a decision to release it. And sometimes I think sometimes it can be implicit when the directions are given. In fact, the directions can be given that it can be disclosed in a certain way. It doesn't necessarily have to be at a meeting. It could be the statements from the city manager who could go and do that. But it's council that has that control, Councillor Carpenter.
And council has to give that control by way of resolution?
Yes.
Okay, thank you.
Or I'm sorry, I spoke too soon. Or directions in camera.
When you make the original recommendation in camera.
Or subsequently, I suppose. Yes.
All right, thank you.
All right, seeing no further questions, I thank you, Mr. Marks Karen, for your informative presentation. And that concludes the meeting tonight. There are no items for consideration, no urgent items.